If you have questions, just be aware that these questions, you can put them in the chat. We will not be answering them until the end of the training, but you can put them on the chat as we go. And now I will turn it over to Justin.
Thank you so much. Um, it's nice to virtually meet many of you. Uh, Events like this are really good about building community. So if you're able to, I would love for you to put in chat if you're connected to any organization and why you're here, such as government, tenant organization, legal services, or anything of that like. Because it's always nice to put a name to a face, and hopefully we can work together in the future. Now, today's training is going to be about holdovers, which is a very broad topic. And each specific holdover, I could easily do a 90 to 2 hour training just on those. So we're going to be going through them somewhat superficially, but the goal of today's training is to give you enough information to be able to help yourselves and your neighbors if you find someone in a situation where they're facing a holdover. So what holdovers are is a particular type of case that isn't necessarily about rent. Holdovers are essentially an eviction case that is not about rent, but about possession of the property, where the owner of the property or the person with a greater right to the property wants you out of the apartment. And they make up anywhere from about 10 to 15% of all eviction cases. So while they're the minority of the cases, they're often very complicated and still relatively prevalent because, 10% of over 100,000 is still well over 1,000 holdovers a year. So there's different types of holdovers that we were going to be going over, and they're based on the law. So what I'm going to do is start on the types of holdovers that affect tenants who are in unregulated units, sometimes called market units. I don't like to use the term market because there is no such thing of a free market in New York City. So we're going to talk about the unregulated units, and then we're going to talk about holdovers when it comes to rent stabilization. Between those two, we're covering about 90% of the tenants in New York City. So let's begin with RPAPL 711. So with those types of holdovers, the most common one we're going to see is what's called a no-cause holdover, meaning that we're not evicting you for any particular reason, but the owner of the property is saying it is time to get out after your lease expires. Now, the lease, before them to bring this case, it has to be done after the lease expires. And then the amount of notice they give you that they're not going to give you a renewal lease depends on how long you've lived in the apartment. If you have lived in the apartment for less than a year, you get a 30-day notice. If you have lived in the apartment for 1 to 2 years, you get 60 days warning. And if you have lived in the apartment for more than 2 years, you get a 90-day notice that you are not going to be continuing to live there, that they intend to let your lease expire and they expect you out after that. So what are defenses when it comes to a no-cause holdover? You have your general defenses. If they fail to serve you, if after they terminate you, they still collect rent, you can't collect rent from someone unless they're a tenant. And that's what's called vitiating the notice. If they don't give you the right papers, that's an issue. If they don't upload the affidavit of service in the proper amount of time, that's an issue. And those things apply to all sorts of cases. Then you have issues of regulatory status. So when you have a no-cause holdover, that only applies if that apartment isn't connected to needing a good cause. So the most common forms of good cause we see in New York City is if you are rent stabilized, or if you're living in public housing or some other form of government housing, you have to have a reason. You can't evict people for no reason. And that brings us to our final point of good cause. This April, we had a new law that passed after years of work by tenant organizers that was able to get through in Albany, establishing good cause for people who are in unregulated units. But the original bill was much broader than what got passed. So we ended up having a lot of exceptions. And I want to talk about how to figure out whether or not a person facing a no cause eviction is protected by good cause. So we got to start going through basically a checklist to see if this applies to you or not. First off is the age of the building. Good cause wasn't meant wanted to exempt newer buildings. So good cause only applies if the building was built before 2009, and the date a building is built is determined by the certificate of occupancy, which you can often find by the Department of Buildings for modern buildings. And if it's an older building, then you don't have to worry about it because we're talking about 2009. Now, the building also could not have been substantially rehabilitated after 2009. And substantially rehabilitated essentially means that three-quarters of the systems within the building had to be redone. We often see this after a major event such as a fire, where the building is completely redone. We're not just talking about superficial renovations. We're talking the building was in deep disrepair or deconstructed, and it had to be rebuilt. Now, they also want to exempt what they called small landlords, and there's no real definition of what is a small landlord. So for this particular law, the definition that they are using is that the landlord must own 11 or more units, or if the owner lives in a 10-unit building, that they don't live in the building. So we're talking about units, not buildings. So if the owner has a 15-unit apartment building, that would be subject. If the owner owns 5 3-unit buildings and you now have 15 total apartments or units, that is subject. So this means that not only do you have to figure out the age, which you usually can do with government records, you have to figure out how many apartments does a landlord own if your own building is 10 units or fewer or 9 units and fewer. And one website I would recommend, and Jessica, if you could add this to chat, is run by our friends at Just Fix, Who Owns What. If you put information about the apartment, they'll give you their best guess about how many units that landlord owes. Now, because of the use of corporations such as LLCs, it's often very challenging for us to track down how many units exactly a landlord owes, but this will give you kind of an idea whether or not they would qualify as a small landlord or not. The next exemption is whether or not this is considered a luxury building. And the way they're looking at it is if it's 245% of the fair market rate, and that rate is determined by HUD, the federal agency that runs housing. Now, I wanted to give an example of how high rent we're talking about. So the lowest amount we're talking about would be for a studio apartment. And for that, it's $5,846. So as long as your rent is under that, you are fair game. But if you are paying $6,000 or more in rent per month, then you may be exempted because of that. And you can find this information on DHCR, among other places, probably Housing Court Answers. So what are some other exemptions? Exemptions apply if the building is cooperative, co-ops, or condos. And if you're unsure about that, you can look up the address at the New York State Attorney General's office on the Real Estate Finance Bureau. They have a list of all co-ops and condos. Now, if your housing is part of your employment, typically we're going to see this with people like superintendents, but it also applies in situations for hospitals often apply housing. Universities will sometimes apply housing for their employees. So you have to, your housing cannot be directly related to your employment. And if it is, then it's a question of when your employment started versus when your housing started, whether you're paying rent or not, it becomes more complicated. And lastly, it only applies to cases that happened after this law went into effect, which was April 20th, 2024. And typically the date we're looking at is when the index number was bought, especially in the second department. So if this is a case that had been in court already, pre-April 20th, 2024, the new good cause rules do not apply. But if, for example, someone just received the notice of non-renewal that the landlord wants them out, that law is into effect for their case. I also want to point out that while this new good cause law is incredibly important and something that should be celebrated, it also is a much weaker version than what was originally asked for by tenant advocates. And we're not done yet. So when you look at the original law or proposed law on the left, there would have been 54 elected officials who would have been covered at this in Albany. By the time they added the exemptions, of the original 47 who were covered, now only 2 were covered. So all these carve-outs are suspiciously appear to also carve out the real estate holdings of our elected officials. So for those of you who are involved in politics, for those of you who want to see a more just society, this good cause will change the lives of many, many tenants, not just in New York City, but for cities across the state that decide to enter into this program. But this wasn't what we originally asked for, and there's still room for improvement because those carve-outs, especially trying to determine how many units a landlord owes, among many other things, will mean that there be challenging for people, especially people who are not up to date on the laws, to take advantage of this. So there's still room for improvement. And because it's a new law, we don't know how the courts are going to treat it. There have not been any published decisions yet, to my knowledge, though quite a bit of motion practice has already started. So our interpretation of this law is going to evolve over time once we see the courts start making decisions that apply it in practice. So now let's move on to RPPL 713. This is state law when we're talking about types of cases. So this applies to holdovers in unregulated or regulated housing when the person who's potentially facing eviction is not a tenant. So what are some categories of non-tenants? First off is a squatter. A squatter is the person who doesn't have permission from anyone who's entitled to give them possession of the property. We hear the word squatter a lot. At one point, the New York Post was doing 2 or 3 articles a day about squatters. But in practice, there's very few squatters. A squatter is essentially someone trespassing, someone who has entered the property without permission of anyone who has the ability to give that permission. More likely, what you're going to see are licensee cases. Licensee cases are where people have entered the property with permission by someone who has the right, whether it's the owner, someone who works for the landlord, or the tenant themselves gave permission. And if you give permission to someone, let's say a friend, to stay over at your house, they are now your licensee. And finally, we have employees. An employee is someone whose housing was incident to employment, as we were talking earlier with superintendent, etc. Now, when it comes to court, the court process vests when there's a contract signed, but in these situations, you're not going to have a contract. But we do have laws to prevent illegal lockouts. The idea being is that we do not want property owners and landlords and roommates evicting people by changing the locks and throwing people in the street. That often led to illegal evictions where people had rights. It often led to acts of violence between people because we are having a fight instead of doing this in a court where we have rules and decorum and procedure. And so anyone who has lived in an apartment for 30 days or longer can't just be thrown out in the streets. You have to go through the court process. Now, in situations like squatters, that process is often relatively quick, but often squatter cases aren't actually squatter cases. You have maybe a licensee case, and it can be more complicated because someone who may be a licensee may actually have rights as a tenant. Maybe they have a right to inherit the apartment through succession or many other things. And this goes just a little bit more in detail. A squatter, again, has to go in with no permission from anyone. And so, like, if the superintendent decides to let someone into it, that superintendent, as the agent of the landlord, presumes to have the ability to give that. So that's not a squatter. That was someone giving them permission. When we deal with licensees, that could be anyone from family, visitors, roommates, friends. And in those situations, you do need to provide a 10-day notice to quit. The notice for non-tenants tends to be very short. Squatters get virtually no notice. Licensees get 10 days notice because these cases are meant to go faster because we're not dealing with a landlord-tenant situation. But when you are doing these notices to quit it, you do have to state why this is a licensee, and it's not just someone trying to get around the rules by essentially lying and trying to claim someone's a squatter or licensee when in actuality they're a tenant. So if that person paid rent, licensees don't pay rent, they're tenants. That's a very easy way to keep track of that. Now, it can be a little more complicated if you're trying to evict a family member. You're looking at whether or not there is a duty to support with family members, because often when you're dealing with family members, housing court may not want to have jurisdiction, and you may instead have to be an issue brought at an ejectment action at the Supreme Court of whatever county you're in. If it's Staten Island, Richmond County, if it's Brooklyn, Kings County. And when you have possible duty to support, you're often going to see that dealing with children, spouses, where there is some duty. And if it's, for example, a divorce case, instead of an ejectment action, that first should probably be decided as part of the divorce proceedings in family court. So when you have familial relationships and evictions among family members, it can be more complicated. And depending on the facts, it may be inappropriate for housing court. And what you're really looking at the fact specific, and it can get very complicated, and there's kind of a mix of case law on there, but you're looking at whether or not there's a support obligation that existed and whether or not that obligation has been satisfied at the time that the eviction attempt is occurring. So what about employment? So when employment, you're looking at, did the employee pay rent? If they did, especially post-employment, there's a decent argument that they're not an employee, there's a tenant. This is especially true if the person starts out as a tenant, then becomes an employee. You often see people becoming porters or supers or assistants with the building, maybe helping take out the trash as a way to get a reduction of rent. And so you're looking at that bright line. Are they a tenant or are they an employee? Employees lose their right to housing upon termination of their employment if it was a lawful termination. And often, especially with superintendents, we see landlords as employers are breaking laws such as the Fair Labor Standards Act, the New York Wage and Hourly Act. And so if there are proceedings happening regarding the labor law, it may be possible to stay as a housing court proceeding until a decision has been made. But again, these are very fact-specific cases. And if you or someone you know are facing a eviction and they're claiming that they are an employee, but it's more complicated than that, this is something that you should talk to an attorney about. So those are the most common types of holdovers that you see when we're dealing with unregulated buildings. And by nature, because they're unregulated, there are fewer rights for tenants. So now we're going to talk about rent stabilization. Rent stabilization applies to over 1 million households in New York City. And rent stabilization comes with many rights and obligations, rights for the tenants and obligations of the landlord. And that if they're not complied with, that means that they can't bring these cases. And so we're going to talk about some of those holdovers now. Failure to renew leases. Landlords have an obligation to offer tenants a renewal lease. They're supposed to do that within, I believe it's 90 days before the expiration of their lease. Tenants then have 60 days to review that proposed renewal and make sure that the terms and conditions are correct. The landlord's not changing any of the terms and conditions, because whatever were the terms and conditions of the original lease remain throughout the tenancy of the tenant. They're making sure that the increase that the landlord is proposing is the right amount. The tenant has to decide, is this somewhere they want to continue living? If the landlord makes a proper offer, meaning proper rent, they didn't change the terms and conditions, the tenant then is under obligation to let the landlord know, are they agreeing to renew their lease or not? And if they don't, but they continue to live in the apartment, the landlord is then allowed to bring a failure to renew case. The reason being is that landlords cannot get an increase in rent until there's a new lease. And if a tenant is trying to become a month-to-month tenancy and the landlord doesn't want to do that, the landlord doesn't have to, and they can force the tenant to choose to either sign the lease or to move out. Now, in the past, landlords could sign on behalf of the tenant. If the landlord or the tenant never got back to them, the landlord would have a stamp and would basically say the word deem on it, and they would deem the lease, and then they would take their increase. But since 2012, that is no longer permitted. So landlords now have to get that renewal lease signed if they want that increase in rent. And if not, then it's up to them to bring a failure to renew case. Now, in terms of defenses on that, sometimes you can cure these types of cases by the tenant signing it, or the tenant can argue that they didn't provide a proper lease. So how would it be improper? If they didn't give enough time for the tenant to review it as required by statute, if it was at the wrong rent amounts, If they were trying to, say, take away a preferential rent, which they are not allowed to do since 2019. Things of that nature. If it was an improper lease, if it had a retroactive start date, where maybe the landlord forgot to mail it out, and now they are mailing a lease that starts 4 months in the past because they're trying to correct their mistake, they can't do that. They can give you a new lease, but it still has to be prospective, meaning it starts in the future. And those would be valid defenses. But beyond that, tenants have to choose whether they're going to sign the lease or whether they're going to move out if they refuse to sign a renewal lease that is properly made. One of the most common, if not most common outside of no cause holdovers, are breach of lease cases. Now, with a breach of lease case, it can't be a breach of any particular statute. It has to be a substantial obligation of the lease. It can't be de minimis. So you're looking at something other than the payment of rent. Tenants can be evicted if they break their lease. But tenants do get the ability to cure. So in advance of the landlord bringing a breach of lease case, the landlord has to provide a 30-day notice to cure. And if the tenant does not cure, and when I say cure, that means stop whatever violation is occurring, the landlord then is able to follow up with a 30-day notice of termination. And that essentially means that if you're not out by this 30-day mark, this is the day your tenancy terminated. After that, the person bringing the case has a right to actually start the court case. And if this case goes to trial, tenants can potentially have 30 days of a post-judgment cure, meaning if they lose at trial, the court can give them 30 days after losing at trial to cure, meaning fix whatever breach we're talking about. Though I will say, if you lose at trial, you also risk potentially having to pay the landlord's attorney's fees. So if this is something where there's uncertainty, or let's say you are breaking the lease because you're upset at the landlord, you don't like that lease provision, as long as it's a legal lease provision, and as long as it's a substantial obligation of the lease, this isn't some minor mistake, you should cure it in advance, because if not, by the time you reach trial, you may owe thousands and thousands of dollars. Also, if the violation of the lease is something that can't be cured within 30 days, sometime that can affect whether this happens. An example of this would be you decide to do remodeling of your apartment, you take out a load-bearing wall, which has now put the building in danger. Doing that sort of modification of your apartment was a breach of the lease. You were not allowed to renovate your apartment. And the ability to go through Department of Buildings to cure you breaking a load-bearing wall is going to take longer than a 30-day period. So depending upon what type of breach we're talking about, sometimes those stays or cures may not be available to you. Or if they are available, they're giving you benchmarks of things you have to do. For, in this case example, a judge may say that I need to see that you have submitted all paperwork, have hired licensed contractor, architect, and submitted this to DOB by this date, and then be repeated check-ins. But often, if it's that sort of situation, the judge may not give you a cure at all. So what are the most common breach of lease cases that we're talking about? I think common ones would be no smoking, if this has a no smoking clause, pets violations, washing machines, air conditioners, dishwashers, if you are prohibited against that in your lease, illegal subsidies or commercial use, such as using Airbnb. I'm going to talk about each of these in just a little bit more detail. So when it comes to pets, if your pet is being a nuisance, which you're going to talk about in a few moments, the landlord's allowed to bring that case. Basically, the pet's doing something, for example, barking at all hours or biting people, that's not breaching the lease, saying your pet is a danger and menace to the people in the building. But if they're suing, saying not the behavior of your pet, but its mere existence is a violation of the lease, that is allowed to happen. However, there's this administrative code, which we call the pet law, 27-2009.1b, that if your pet was kept open and notorious for 3 months, and the landlord knew or should have known, that they can't bring this case for that individual pet. So the easy type of these cases would be a dog. Open and notorious means, hey, you have a dog, you walk it 2 or 3 times a day. Maybe you order dog food through the mail so people would see it in the mailroom, or pet toys. You're not hiding it. Now, with other pets, it may be a little harder to be open and notorious. If it's a cat, you might not be walking your cat. But if, for example, you have agents of the landlord come into your apartment and do repairs, and clearly a cat lives in that apartment, maybe you have kitty litter or cat toys that were open, that this was not something you were hiding, that might be a way of showing that this was open and notorious. And also, it has to be a pet that could be legally owned in New York City. There was a famous case in public housing where a person had a pet tiger and a caiman, which is similar to an alligator. Those are not allowed to be pets. So whether or not you were open and notorious for your tiger, that would not be permitted. Now let's talk about appliances such as washing machines. Landlords, if it's in the lease, are allowed to prohibit it. Often they're going to say we don't want washing machines because they're too taxing to our water system, or because of the risk of them having a leak. Now, you may be able to ask for it as part of a reasonable accommodation if you're a person with disability, and having a washing machine may be related to a disability that you have there if there's a medical reason. Um, Reasonable accommodation is kind of an exception to leases, being like, I know this is in your lease, but I'm asking that because I'm a person with disabilities. Similar to pets, if you are visually impaired and you want a seeing eye dog, even if there is a no pet clause, a reasonable accommodation may be a way to where you can nullify that because you need that in order to live your life for a medical reason. But if you don't have a medical reason and the landlord does prohibit having these certain appliances, then you can be evicted for that. Now, the common defense of that is breach of leases is a contract, and you're not allowed to bring breach of contract cases. The statute of limitations or deadline to bring that case is 6 years. So if you've had this washing machine for 10 years, it's too late for the landlord to be bringing this, or at least that's the argument you would try to make in court. And remember, I am not your attorney, and all facts specific cases are not necessarily going to be applied by the general rule, but these are defenses that you could potentially bring up. Another argument is waiver. And the waiver is if the landlord was aware that you had these appliances or should have been aware you had the appliances and didn't act upon it for years, they may have waived the right to bring the case. So again, when it comes to the argument of appliances, if the super knew you had the dishwasher or the washing machine, they've been in your apartment, it's very easy to see this wasn't something that was hidden. And we're talking about appliances that are installed, not something where like let's say some dishwashers, you just hook up a hose to the sink. That's different. In that case, the landlord may have lost their ability to sue for this because they've waited so long to bring a case. Illegal sublets. So a legal sublet is you need permission to allow other people to live with you, but there's rules that are surrounding that. So for one example, if there's only one name on, let me just see, I think the next slide may say this. Let me look. Nope. Okay. If there is only one name on the lease, you are allowed one roommate. So the landlord does not have the ability for unsubsidized housing. Where this is different if you're living in subsidized housing, such as where your rent is based on your income, or if you live in housing where it's based upon a characteristic such as senior housing, there may be that this rule may not apply there. But in most housing, where your rent is not connected to your income or based upon a characteristic of who you are as a person, then if there's only one name on the lease, you're allowed one roommate and the landlord doesn't get to choose that. Now, if you have two names on the leases, so it's you and your roommate, then you don't get an additional roommate. The roommate law is only in situations where there's one name on the lease. However, if the people you want move in with you are family members, that is permitted. And there's no limit on that as long as you're not exceeding the occupancy level. And when I'm saying occupancy level, we're talking about how many people are you allowed to have per square footage. And if it's to the level there's such overcrowding, it's a danger by city statute, that may be a problem, but that is a very rare situation. Now, if you want to sublease the apartment, the rule is on Real Property Law 226B, and that you do need to get the landlord permission, and the landlord is supposed to respond reasonably to that. In practice, this is hard to do, and the reason being is you need to ask in advance of the person moving in for the permission, and generally the landlord's looking to see whether or not they have the credit worthiness and income to be able to live in your apartment, excuse me, short term while you are gone for whatever reason. Um, but if the landlord says no, um, generally speaking, when you're trying to get a sublease because you need to go soon and it comes down to timing. And this often the timing, if the landlord says no and you need to go, now you need a new person, start the over process again. Or maybe the subleaser doesn't want to wait for this landlord who may or may not get back to you because they don't want to be in a situation where they may be evicted. So we see a lot of fights about this, and it's kind of hard to enforce, but it is important if you want to do it the legal way to give the landlord advance notice. And if they're being unreasonable, and then that's something you can dispute. But I will say in practice, this is harder to do than it looks on paper. And lastly, Airbnb. To Airbnb a unit, you need to be registered with the city or it can be a violation. And there's a lot of bad case law about the commercialization of apartments. And that's under this Goldstein v. Lippitt's case, which was First Department Appellate Division, where essentially you could just be evicted by Airbnb your apartment, especially if you're overcharging, meaning you're charging more, you're making money by using Airbnb. This isn't just you trying to make back because you're out. This was a way for you to make money, even if it was small amounts of money. People get evicted over this. And I've seen some very sad cases where a widower whose spouse passed away, but the spouse was a person who was the income earner. And now the only way they can afford the apartment is to do Airbnb, and like they could face eviction over that. And so it's generally speaking, it's not worth taking that risk. So now we're going to talk about nuisance holders. Unlike breach of lease holdovers, nuisance holdovers, you are not allowed to cure. The idea is whatever you're doing is so bad that the time for curing is over and that they're going to evict you. And so what are some common cases we see for nuisances? I have a list here. Abusive behavior, smoking, offensive conduct, clutter, acts of violence, repeated water leaks. The person leaves a bathroom's tub running and then it floods a unit below. The apartment is kept in a fire hazardous condition. Noise, acts of crime, having a pet who's, let's say, odor, noise, endangering physical safety. All these things are commonly used in a nuisance case. Now, what we define as a nuisance, because with nuisance, it's very much in the eye of the beholder. Some things are very objective. On a failure to renew a lease, did you sign the lease or not? That is an objective test. When we're dealing with a case of nuisance, it's a very subjective. And so now we have to worry about maybe racial prejudices and bias because of different cultures. We're worrying about maybe people are just live differently. And so the question of, is this difference, can this be considered a continuing course of conduct threatening the life, health, and safety of the landlord and other tenants? Because that's a test that the judge, and when it comes down to subjective, that's the person who's going to make a decision. He or she is going to be the one who looks and will have to consider whether or not this is threatening the life, health, and safety of others. Now, typically, a single incident is not going to be a nuisance. So let's say a situation where a person, we talked about, left the bathtub running. Doing that once is not a nuisance. Doing that 3 times probably is, or at least potentially could be, depending on the facts. So we're talking about a single act versus repeated acts. And a nuisance doesn't have to be the same act over and over again. If you accidentally started a fire by leaving things on the stove, if you leave the apartment in such bad conditions, it is infested with vermin and smells, those may be unrelated acts, but the accumulation of them can still rise to the level of nuisance, and they're not considered a single act. They're looking at them in the totality. But just being different is not a nuisance. Someone can be eccentric. Someone may not get along with another person, but that alone doesn't mean they should be evicted. Owners' use cases. We don't see these as much, but the owner of a property, if they own the property in their own name, meaning this isn't owned by a corporation or an LLC, the property is owned in an individual's name, that person may have a right to take an apartment for either themselves or their direct family members. Now, if they want to do that, they're not claiming that the tenants who are living in that unit have done anything wrong. They don't have to show that. They have to give that person notice, what's called a GOLB notice, a notice of non-renewal. So they're going to need to give them at least 90 to 150 days notice that we're not renewing your lease and we're going to want it for either myself or my immediate family. And they're going to need to identify some key things about what family members are going to do and maybe some details on why the family member needs this unit. Now, as I said, it can't be a corporation that owns a property. It has to be an individual. And when I say immediate family member, we're talking spouse, children, stepchildren, stepparents, siblings, grandparents, grandchildren, and in-laws. If we're talking like a friend of a friend, a cousin, that's not going to work. Now, HSTPA, the rent laws that passed in 2019, made these a little bit more stricter. And this is just talking about the GOLB notice, which I just mentioned. Another term we're talking about is, excuse me one second, is the window period. Because if the landlord doesn't send this notice in the window period, 90 to 150 days before your lease expires, then they brought the case incorrectly. And then they have to give you a new lease and then start the case over again 90 to 150 days when that new lease expires. So it's very important. So if they send you a lease after your lease has already expired, can't do that. If they send it 89 days or 151 days, then they're in violation. The window period is very important in these type of cases. So landlords are limited to only taking one unit. So in the past, landlords could take multiple units. There was an example of the Economakis family who owned a lot of real estate. They took over a 10-unit building in the East Village and took it all just for themselves. So now they can only be going after one apartment. The landlord has, before they just showed they intended to use it, and usually we show that intent by, look, this person needs the apartment. Here's my plans for that. Usually we get discovery in this case where the tenant would be able to get information from the landlord about their plans for the apartment to show that they actually were going to do it. Now, after the change of law in 2019, the landlord must show an immediate and compelling necessity. There's not a case law on what that means, but there's this higher standard. And because of the higher standard, we're not seeing as many of these cases. I know a couple of them floating around, but they're just not as many. And the apartment of the person going to live there has to be for their primary residence. This can't be some vacation home that they visit. This can't be something that they're only going to be using for a short time. This must be their primary residency. And I believe the test is for the next 2 years at minimum. Now, if the tenant or their spouse meet certain qualifications, then it becomes much harder for the landlord to do this. Now, again, the law changed in 2019 on this as well. So now, if the tenant or their spouse is a person with disabilities, is someone who has lived in the apartment for 15 years or more, or is 62 years or older, and this is not at the time the case starts, this is at the time when the case goes to trial. If that happens, the landlord can still bring an owner's use case, but they must find an alternative apartment that is as good or better. And when I say better, we're talking about like the quality of the apartment and especially the rent of the apartment in the same proximate area. So when I was a law student, I was doing housing work as well. And one of my first clients was a disabled individual who lived in the West Village, whose rent was probably $400. And a very wealthy celebrity wanted to take this person's home from them because they wanted more space. But to do that, they needed to find a $400 apartment in the West Village that was rent regulated. And the reality is that they're not going to be able to. And so often, while this doesn't by law prevent someone from being evicted, in practice it can. Now, sometimes landlords will offer, especially when they're very motivated, may offer to buy someone a co-op or condo, or may try to make a buyout agreement. But tenants are in no obligation to accept that. So now we're going to talk about non-primary holdovers. What this means is that tenants in rent-stabilized apartments are required to actually live in those apartments. And the test for that is Does the tenant have an ongoing, substantial physical nexus with the controlled premises for actual living purposes, which can be demonstrated by objective empirical evidence? So notice that they're wanting to use objective empirical. They're trying to get away from the nuisance eye of the beholder. They want something tangible. Now, if you look at the statute a little deeper, which I'm not going to bore you with, they give some examples, but there's no one thing they look at. They're supposed to look at the totality of the circumstances. So some examples they're looking at is, does the tenant live in the apartment 183 days or more? Meaning, are they there for half the year or longer? If you want to go live in Florida during the winter, you can do that as long as you're spending the majority of your time in your apartment. Another thing they're looking at is what address you use for voting. Voting is a felony if you're registered to vote somewhere that's not your primary residence. So they're going to assume that you're not committing a felony, and where you register to vote is going to be very persuasive on where you primarily reside. They're going to look at where you tell the government you live, and this is separate from the voting, but we're looking at, for example, tax returns, driver license, things of that nature, utility bills, of where are you showing the government that you live by informing them of this information when you have an obligation to give your address. And then the last factor that they define is if you're subleasing the apartment. If you're renting out to the apartment to another person while you're gone, that is going to be evidence that they're going to use against you as a non-primary residence. Now, similar to owner's use cases, they also have to do a Gollum notice, meaning that to bring this case, they have to give a 90 to 150-day notice of non-renewal. But unlike owner's use cases, in these cases, the tenant doesn't take discovery on the landlord gets discovery on the tenant. And the relevant period of time is typically the 2 years prior to the expiration of the termination notice. So you're looking back 2 years, but the court may review the entire history of the tenancy. Owners are going to argue looking at the entire history of the tenancy means that they should be able to look back 10 years. Tenants are going to argue that, hey, if the person has lived there for 50 years, they should give some credit for that if maybe the facts are a little bad in the last 2 years. So the burden on the landlord is not to show where the tenant lived, but where they do not live. So the landlord doesn't have to say, oh, this person is living not at 100 Broadway in Brooklyn. They're living at 105 Broadway in Manhattan, or they're not living in New York City. They're living in North Carolina. If the landlord knows they should state that, because that's powerful evidence and they have an obligation to give some details about why they're bringing this case. But that's not something that they have to prove at trial. Now, there are some exceptions where if you're not in the apartment, that by statute, the court recognizes shouldn't be held against you. If you're in active military duty, and maybe you've been gone for the last 2 years, but that while you may have been gone, that doesn't count against you. If you're rolled as a full-time student, and full-time means 12 credit hours or more, and let's say you are studying out of state for whatever reason, maybe you got a scholarship, maybe there's a program that meets your needs there. That's allowed, but only if you're a full-time student. If you're only working as a part-time student, then this exception does not apply to you. And again, 12 credit hours is what's considered full-time. If you're not in residence because of blah, 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 what they're getting at in this situation is if you're not there because of a reason that you don't want to be. So the biggest example, let's say someone's in prison. If you're not gone because of by choice, you're gone by force. Other common examples you see is someone in a rehabilitation center because they had a medical condition, they need time to recover. And speaking of medical, hospitalization doesn't count if you're receiving medical treatment. If you're temporarily gone for employment. So if work requires you to travel, that's permitted, but it's a temporary travel where you are allowed to return going home. This isn't going to be a long-term relocation. And then finally, they give a catch-all. If you have a good reason, so there's going to be a lot of cases potentially arguing that people were out during COVID. Now, if you're arguing that you left the city because of COVID, then they're going to look, how long were you out of COVID? And if you were gone, let's say, for many years and years after the COVID emergency was deemed gone, even though COVID still exists and the numbers are frankly not very good right now, the timing is going to matter to the court. And they're also going to look at those other factors we talked about. Where are you registered to vote? Did you have intent to return? And did you demonstrate that intent to return by like where your driver license is, where you have your mail sent, where you filed your taxes, things of that nature. Again, talking about the Gollum notice. So when I say discovery, these cases often involve a lot of papers. So anything that may have your address, and I have a big list here, is going to be fair game. Often landlords, I've seen in cases where landlords, and they're legally allowed to do this, will install a camera right in front of an apartment door. Now they can't put a camera inside your apartment, but if it's in a public hallway, case law allows them to do that, to see whether or not you're coming in and out of the apartment. Any kind of bills, medical records, anything that shows where you live, like where you spend your money, taxi, Uber, Lyft, ATM records, dating apps to show like what location you live, social media. All that potentially is fair game and discovery, where while you may get to redact some of this material, the landlord may ask and the court will authorize the landlord to get access to all this information from you. And it's a very laborious practice. So if you're thinking of living from your apartment for a while, you're allowed to be gone for a short period of time. But if you're going to be gone in a 2-year period for, more than 183 days a year, you are potentially being at risk. And if you live at a rent stabilized apartment and for whatever reason you haven't updated your records, such as your driver license, it's annoying to go to the DMV, but that stuff does matter in court. And while none of these things are definitive, they all are given weight by the court. And so the more things that are on your side, the better chance you have to win your case. Chronic rent delinquency. So when I talked about holdovers, the way you differentiate them from non-pays, which is the majority of eviction cases, is that it's not about rent, it's about possession. Chronic rent delinquencies are kind of the mutant of non-pays and holdovers. They can be brought as a nuisance case, but more often than not, they're brought as a substantial breach of lease case, and that's because of Sharp v. Norwood. And essentially what the landlord is saying is that you keep being behind on rent, and you're forcing the landlord to spend money to force you to pay your rent, whether it's bringing you to court or generally by bringing you to court. And because of this, because the duty to pay money is a requirement of your lease, and if it has this long-term unjustified persistent failure to do so, when rent becomes due, you can be evicted over this. Now, if you owe money once, that's not going to be enough. But if the landlord has brought you to court many times in a short period of time, then you run risk of facing a chronic rent delinquency case. And unlike most breach of lease cases, at least in the first department, the appellate term has a lot of case law on that, less so in the division or the second department, where Brooklyn, Queens, and Staten Island are, that there's no right to cure, meaning you just can't cure the case and expect it to go away. Now, you can have defense to this. So the biggest defense is you withheld rent because you needed repairs. You have the right to withhold rent in New York, no question. But withholding rent also means that you have the rent. So if your argument is, I have repairs, but also I didn't have the money, that isn't given as much weight as I had repairs and I was withholding rent to force the landlord to make those repairs. Statute of limitations, different judges will come out in different ways. Some cases will say that the prior court cases needed to be within the last 6 years. Some judges say that doesn't apply here. So this is still open to interpretation. The landlord has only brought 1 or 2 non-payment cases. The vast majority of cases will say that's not enough to constitute a chronic rent delinquency. If there were valid disputes over what the rental amount was, for example, a possible rent overcharge, that is a very valid defense. If the non-payment cases were brought incorrectly, they're not counted against you. If your source of income was outside of your control and you were diligent in trying to correct it. The 2 biggest samples I've seen of this is a very old case when it came to alimony, where one former spouse withheld alimony to try to get their former partner evicted. But they went to court to let them know that this wasn't coming. They made efforts. The court wasn't going to penalize the tenant in that situation. The more common scenario I see is where someone's income is related to their government benefits. Let's say you are a government subsidy, but then the government makes a mistake and stops paying or pays the wrong amount. If you can show the court that you are diligently trying to correct it, you requested a fair hearing, you have notified the government that the reason for that problem isn't something for you did, but their mistake. I've seen that to be a valid defense. Or if the landlord just brings lots of cases but then doesn't pursue it because they're artificially trying to inflate the number of cases they bring you, that is an argument you can take because, they're not looking at the total number of cases in a vacuum. They're looking at, is there a persistent, unjustified failure to pay? And if they don't see that, then you may be able to avoid this. Often these cases end up in situations where people go on probationary stipulations. And those are very worrisome because often, especially for people who are unrepresented, the terms of those agreements are very one-sided, where if the person is late one or two times, that they can be evicted. And so if you're facing one of these, again, it values talking to an attorney. Even if they don't represent you, they can give you information about how you can approach the case. All right, illegal use proceedings. So these fall under both 711.5 and 715 of the RPAPL. So we're going to talk about that. Now, I also want to point out, I was very clear at the beginning, but I see quite a few people have joined us. We're up to 90 participants, that I'm talking about, in this particular case, unregulated and rent stabilized units. I'm not talking about public housing, especially on this one. While some of what I'm telling you applies to public housing, in many cases it doesn't. And in public housing, the rules are much more strict than what we have here. So I just want to make sure people are aware of that. So an illegal use case is a situation where the landlord is claiming that you are illegally using the apartment, and that typically means gambling, sex work, or drugs. Now, the standard to evict a tenant in that situation is, did the tenant know or should have known of the activities and then acquiesced to those activities? So a common situation is, let's say a grandparent is living with a grandchild. That grandchild turned out was selling drugs illegally, and they kept those drugs in the apartment, but it was somewhere hidden. And while the drugs were in the unit and there was drug activity happening, that the court could find that, it was reasonable that the tenant of record, the grandparent in the situation, didn't know it was happening. And so while they may have to exclude the grandchild, who may or may not be going to prison, that they can remain living there. This is very different than the NYCHA context. In the NYCHA context, under a US Supreme Court case, Hud v. Rucker, in a unanimous decision with very similar facts as that. In this case, the activity was happening in the parking lot of the building, not even in the building. Those same grandparents are permitted to be evicted. So it doesn't matter their level of knowledge, it just matters of whether something occurred. But in New York law, when we're not dealing with federal law because of NYCHA, public housing, the knowledge of the person and the reasonableness of that does apply. Now, that doesn't mean that the person just closes their eye and go, la, 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 I don't hear or see anything. If the court thinks the person should have known and they were willfully being blind, they can still face eviction. Now, this is similar to 715. Now, 711.5 is grounds for the landlord to bring eviction case. 715, for similar reasons, but the person who initiates this is often the government. Usually the district attorney, though occasionally NYPD themselves, and they will tell the landlord, hey, this activity, typically it's going to be related to drugs, is happening in your apartment, and we want you to evict them. So this is a situation about who you vote for district attorney plays a big role in how this applies. Because when you look at the data, certain counties will have a lot of these cases versus other counties who will not. And so in this case, if the government tells the landlord, you need to bring this case or else, if the landlord fails to bring that case, the government will actually bring the eviction case, and the landlord will actually have to pay the government the cost of them bringing that case. So generally what's going to happen is that the landlord will bring on that case because they were told to, but they wanted to handle the case as a way to control the cost. And again, the test, similar to 711.5 for 715 on illegal use cases is, does the alleged use itself constitute an illegal trade or business? And did the tenant either know or should have known that it was happening? And this is a very fact specific. So for example, if the tenant is someone who's visually impaired and can't see, they would take that into account, the reasonableness. It's not just the reasonable person in abstract, the reasonable person in the same similar situation, the facts of the situation we're talking about. So I think I got all that in an hour. I see a lot of things in chat. So I am going to give myself a minute to drink some water. And if my colleagues at Housing Court Answers could start collecting questions, I'm happy to take questions at this point. Though remember, I'm not your attorney. I will talk in generalities, but I cannot give you legal advice.
Should we take like a 2 or 3 minute break real quick? Give everyone a chance to stretch their legs. You're on mute. So.
Absolutely, that's fine with me.
Okay, great. So let's come back at 3:04.
Okay, so I think we said we would start at 3:04, right? Okay. So I can just read out the questions and just remember the questions should not be case specific. We can only answer general questions. So are apartment houses with less than 6 units, but who once had accepted scree or jury rent freeze program still rent stabilized? I don't know if you can answer that.
Yeah, so there's a couple contradictions in that. So so let's take a step back. So to be rent stabilized, you have to have 6 or more units built before 74 or receive a tax credit. So for example, a 4-unit building or a 5-unit building under 421A would still be rent stabilized. A 3-unit building with 421A would not be. Rent control buildings, if we're talking about people who have lived in that building going back to the 70s, could be in a unit building with fewer than 6 units. SCREE and DREE only apply to rent regulated units. And for those of you who don't know, if you are in a rent stabilized unit, you pay more than 30% of your income towards rent, and your household income is 50,000 or less, you can get your rent frozen. Highly recommend you apply for that program. So for a building that has less than 6 units, they shouldn't be getting SCREE or DREE unless they are rent stabilized for some odd reason. So some odd reason would be a tax credit. An odd reason would be it wasn't rent stabilized. There were units that were rent controlled. Or this is a situation where there might have been units that were combined. So at some point, there might have been 6 or more after and built before 74. But then units were combined and now there's 5 or fewer. Those existing units would still remain rent stabilized. And if you have a question about your individual unit, you should go to DHCR or Just Fix and request your rent history. And that'll tell you what the landlord told the state agency in charge of rent stabilization going back from 1984 to present. Doesn't mean that information is accurate, but it'll give you a sense of what was claimed to the government going back now 30 plus years.
Okay, so the next question is just clarifying, good cause only applies to buildings built before 2009. Is that correct?
Correct. That is something by the law that was passed, it is limited to 2009 or older. Unless the building takes tax credit and is rent stabilized, then the good clause law doesn't apply to that. And then we're talking about rent stabilization. So that would be buildings that take J51, 421A, 421G, or the newest one, I believe it's 485X. I may be wrong on that, but no building has been built with that because that law was just passed in April.
So I'm just gonna rephrase a little bit because it's about legal assistance. So it's basically how can you get legal aid assistance for a squatter or licensee?
Um, Anyone who's facing eviction and is 200% AMI, which I don't know offhand, but it is considered low income by the standards, may qualify for right to counsel. But I will say that the need exceeds capacity. So there's a lot of people who need help. And if people are picking and choosing, if it's an actual squatter case and you have no rights, you are much less likely to get an attorney in practice because there's not much an attorney is going to do in that situation. But if you're interested in getting an attorney, you can call 311 and they will connect you to the legal service office who's handling phone calls that day. Also, at the first court appearance, when you're facing eviction, you'll be connected to an attorney and they will check to see whether or not they can represent you. And then if you also just do a search and, for example, Housing Court Answers, they can give you a list of legal service offices that provide free representation to tenants.
So what happens when a landlord sends a tenant to court alleging hoarding?
So clutter cases can be brought in a few different ways. I have a colleague, Ali Kirchhoff-Corey, who's done some great work on this. Typically, these cases are brought as either a breach of lease or a nuisance or both. So part of it depends on whether it is legally an issue or not. People are allowed to have possessions, but then it's a question of do the possessions present a threat to people's health and safety? So things you're looking for is, are there pathways to get through there? If there was are there odors? Are there vermin? If that exists, that's going to be a big issue. If those things don't exist, then you're looking for if there was a chance of a fire, could someone who's wearing the equipment of a firefighter be able to walk through the apartment comfortably? because they're trying to see whether or not it's a danger. They want to make sure that you have access to the bathroom, to the fire escape, to the window, that the outlets are uncovered, that there's stuff not covering the stove. If it's a situation where the clutter, I don't like using the term hoard because hoard is often related to a clinical definition, though it's very real. If the clutter is to the point where it's a legal problem, often it's a question of then, can it be cured? And cure could mean that person or their community works to get it into, it doesn't mean everything has to be thrown away, but get it into the point where it's considered legally safe. There's also for senior citizens, adult protective services will sometimes step in and do a heavy duty cleaning, and they will come and assist with the cleaning, though often it may not be the most nuanced cleaning. And then there's also issues of reasonable accommodation, which those kinds of things you should probably talk to an attorney. And how it goes really just depends upon the nature of the apartment and whether or not the person, if a problem does exist, has the willingness and the ability to do so, because often this is connected to a medical condition. And it can be very hard for people to declutter. But once it's in the court system, it may be necessary if they want to continue living in their home.
Can pregnancy, childbirth be used as a reason for needing a washing machine?
I would say no. I don't believe childbirth, having a child is considered a disability. As someone who has 2 young children, my lack of sleep may get me close to that edge, but legally speaking, unless there's something in addition to that, it is not considered a disability.
If an owner sends a tenant a notice to terminate and claims that he wants the unit for his own personal use, but there are vacant units in the building, can he go ahead with the case in housing court?
I will say that is a question of fact for the court. I have litigated those cases where I pointed that out, and it's going to be up to the landlord to state why this particular unit is needed. But I will say there's mixed case law when it comes to that. But in my personal opinion, I think that should be a factor the court considers, but I don't think that fact alone without giving the owner of the property to explain why. So pretend I'm a landlord attorney. If I need that unit because it's on a lower floor and the person I want to move in is someone with mobility issues, then I might need that lower floor even though upper units are available. So there may be like a good faith reason why that particular unit is needed. But that is something that, if that's brought up, should be brought to the court's attention, and the landlord should be forced to explain why they need the particular unit they're seeking.
What if a landlord stops cashing your checks and then says you didn't pay?
So that would be probably a non-pay case, unless we were talking about the context of a chronic rent delinquency. I will say, after a landlord sends a notice that they're evicting you for a holdover, notice to terminate, the notice of renewal, the landlord legally should not be cashing your checks because they've stated they've terminated your tenancy. You are no longer a tenant. And if they cash your checks, they're sending mixed messages. And the case can actually get dismissed if they're cashing your checks before the first court date, because you can't say, hey, you need to get out, you're not my tenant, but at the same point saying, where's my money? Give me that check. So if it's that situation, the landlord actually is doing what they're supposed to do legally. And then once the court case starts, often there'll be an agreement written. Landlord is able to accept the use and occupancy, which means rent for people who are not tenants, without prejudice to them getting their case dismissed. Now, if this is before a court case starts, and it's just the landlord's not taking your checks on a non-pay, there is a defense to non-pays, which goes outside the subject matter of this presentation, called tender and refusal. And you can document that being like, I've paid, the landlord has refused, and that is a defense in a non-pay case. Though I will state, practically speaking, I would still put that money aside, whether it's money orders or if it's money in a cash in an envelope, put it aside and don't spend it in case a non-pay starts, so that way you have it. But you can use a defense of tender and refusal for that particular action.
So this training is just related to New York City. So in New York City, after eviction is filed, can landlord accept partial payments from tenant? Just to follow up on that previous question.
Could you repeat that The timing matters.
After an eviction case, after eviction is filed, can landlord accept partial payments from tenant?
So we're again, it depends if we're talking about non-pay or holdovers. In a non-pay, they may not want to. It also depends on timing. So I'm going to focus on holdovers because that's the subject of today's presentation. When the landlord gives notice that I want you out, at that point, the landlord should not be taking your rent money from you. At the first court appearance, then because the idea is the reason we have this window period is we don't want to send mixed messages. The idea that notices should be clear and unequivocal. I want you out, period. When you say I want you out and pay me rent, only tenants pay rent, and now you're sending mixed messages. And that confusion, as a tenant attorney, I would argue to get a case dismissed because of that. After the eviction case has been started and you're in court, at that point, the landlord can start talking to you about use and occupancy, which is basically paying the rent during the court case going on. And so I hope that answers that question. And then if you've already been evicted, you don't pay rent after you've been evicted, though you may have a money judgment, but at that point, you're just paying a debt, like you'd be paying a medical debt or a debt to a credit card company. But that's going to be different.
Somebody wrote, what about Mitchell Llama properties? I'm not sure what that is in reference to, if they want to clarify the question. But somebody asked, can you repeat the rent freeze explanation?
Oh, so Scree or Dree. I think Jessica might have put some very helpful information about the rent freeze program in chat if you want to look at that. But the general rule is for tenants who are seniors, and that's Scree, or for tenants with a disability, that's Dree. If you live in a rent stabilized apartment, that your that you are paying your rent burden, meaning more than 30% of your income goes towards paying rent, and your total household income of everybody who lives in your apartment is $50,000 or less, you can get your rent frozen and you have to just renew that. The landlord still gets the increased money with the renewal leases every few years, but that money is paid through a property tax exemption done by the Department of Finance by New York City. It doesn't come out of the tenant's pocket. So it's a really good program for tenants who are senior citizens or with disabilities who meet those qualifications I just stated.
How many days does a landlord have to serve the tenant? What can a tenant do if they see an upcoming case on nyccourts.gov but did not receive paperwork? The landlord is also holding / returning mail for the household.
So this was very specific. So again, I'm going to talk in very generalities. If a hypothetical person knows that there's a court case but didn't receive papers, I recommend showing up in court. If it's a holdover, the very first appearance, it'll tell you what date, there'll be a court date scheduled, unlike a non-pay. Excuse me 1 second. I'm gonna cough, and I'd rather not do that in your guys' ears, but. So with a holdover, you're going to have a particular day on the court paper saying your court date is in this room on this date at this time. At that court appearance, I would inform the court. I never received notice that this court case existed. I only found out because I guess they were checking the court's website. So I'm assuming they had some reason to check the court website. But that's an issue of personal jurisdiction. And that needs to be told to the court at the very beginning, because if that's not brought up, you could waive that defense.
Do the papers served on the tenant after court case has started have to say holdover on them, or how do you know otherwise?
The court papers have to tell you, well, you have your predicate notices and then the petition. So you have a series of court papers. You have the original papers notifying you, I want you out, please stop doing this, or you have to leave, or I'm not giving you a renewal lease. So those are going to tell you the reasons. And then when the court case starts with the petition and notice petition, often it has to state why you're being evicted on there. Often you're going to have the word holdover written on, like, let's say a top right corner somewhere. But like a lot of what's in the petition is required by statute. And so it's not going to be a lot of change, but there is some formatting differences that different landlords are going to use. But it will tell you why you're being evicted in those papers. If they didn't, then the case would be dismissed if it doesn't explain why someone's being evicted.
So you mentioned that NYCHA has stricter rules re holdovers. Do the same rules apply in Mitchell-Lama housing as NYCHA projects?
So Mitchell Lamas is a form of cooperative housing. No. So public housing, Section 9, NYCHA, as we call it here, is different than Mitchell Lama. Mitchell Lama has their own statutes and also often your own proprietary leases. And so the rules are going to be different.
Somebody mentioned they have a client whose landlord filed a case in the Supreme Court for nuisance. Why wouldn't this case be filed as a holdover in housing court?
Strategic choice. So, for example, if it's a nuisance, maybe the landlord is seeking an injunction, meaning a court order to stop doing something. You can get that at a very early stage at Supreme Court. You're not going to get that at housing court. Injunctive relief is limited on what the housing court judges are empowered to do. So that could be one reason. More cynically, sometimes people may be bringing cases at Supreme Court as a way to avoid the right to counsel program because they don't want the person to be connected to an attorney. So that's something I always fear. There's different reasons they may be. Some of them could be very legitimate strategic choices by the landlord. Some of them may not be. I can't tell you why someone's going to do something. I can just tell you the differences between the two.
We actually have a question from YouTube. How do I proceed to do discovery on a service company that improperly served me? Can I ask for certified or registered mail receipts?
So the service company, so the proof of service should be on NICEF. For all cases that have started within the last few years, we now have e-filing. If your court case was started in 2020 or earlier, it may not be online, but for cases 2021 through present, they probably are. And so if you go on NICEF, NYSEF, that's the court's website where all the court papers are, and look up your court case. The proof of service should be at most part of your court file and online. Now, if it's online, it's going to have an affidavit from the person who did the service, and they usually include the receipts of them if it was done by mailing, that there's proof of mailing involved with that. So there wouldn't be discovery, that should already be available. Now, if you're trying to get a process server's records, that's different. So in the situation where someone said, I never received notice, if someone like claimed they personally served someone at the apartment, a process server is going to have a logbook stating everybody they served and also GPS records. And by that, you have to do a FOIL request, a Freedom of Information Law request, to the Department of Consumer Affairs, who are the ones who regulate process servers. And that's something that you probably should talk to like the help room in court to do. And that's if you're challenging processing. I was never served the court papers at all. And if the landlord's claiming that, it would be one way. But if just to get the proof of mailing, that should already be part of the court record that you have access to.
Should tenants work with an attorney if they have a holdover case against them?
In general, I think having an attorney is better than not having an attorney. I think talking to a knowledgeable attorney is better than not talking to anyone. But I use knowledgeable. There are a lot of attorneys who are not really tenant attorneys, but are happy to take a couple $100 from you to tell you something that you could have found on Google. I do recommend making sure that you're focusing on either a private attorney who focuses on representing tenants, or a legal services organization that has a strong history of doing tenants' rights. And you can talk to more than one. You're allowed to do that unless you hire one. Once you hire an attorney, you shouldn't be fishing around. But you're allowed to get advice, and it's better to have, it's better to talk to people than not. Now, you may disagree with them. I will tell you, most people who disagree with me, I think they're making a poor choice, but occasionally they may be right. I don't know everything. But it's usually better to talk to an attorney and not. And that's the whole point of right to counsel program. You look at when right to counsel program started in 2013 versus 2019, right before the pandemic struck, the number of evictions fell by like 45%. And while not exclusively, a large portion of that was more people had access to attorneys and were able to dismiss cases that should not have been in court or able to navigate systems of bureaucracy, similar to my colleagues at Housing Court Answers, to make sure people got the services and help that they needed. So I usually recommend talk to an attorney.
Yeah, also just want to mention the free attorneys and housing court, they do not charge. So if you're being charged, just make sure it's a legitimate attorney. Yeah. In Mitchell-Lama, if a tenant has a washing machine or dishwasher, would the 6-year statute rule apply?
That would be too fact specific. So if we're talking about the dishwasher, that's going to be dealing with a proprietary lease, but you're also dealing a little bit different when you're talking about cooperative housing because people are also like part owners of that. And it also depends on why they're bringing the case. Is a dishwasher causing a leak? That is more of the nuisance category. If it's just its mere existence is violating the lease, that's a breach of lease. So I rather not talk about that because I feel like I would want more information.
Um, can a co-op shareholder get served a holdover case? If so, is the process similar to an unregulated tenant served with the holdover case?
People who live in cooperative housing. So if they're a shareholder, so we're not talking about a tenant. So you have a lot of tenants who lived in an apartment before it converted to cooperative housing and they remain rent stabilized. When you say shareholder, I mean you're probably someone who owns part of the apartment. You can be evicted. The process is different and it really depends on what we're talking about. What happens in Mitchell Lamas are going to be different than what happens in HDFCs, what happens versus regular cooperative housing. It's very fact specific and can be complicated and also depends upon what are the agreements that shareholders have signed onto with that apartment. And those agreements can be changed based on actions by the board of those cooperative housing. So you can be evicted, but the processes really depend on the type of housing and also the rules for that specific building.
Yeah, so there are some questions that we would not be able to answer for this training. But you can feel free to call us at 212-962-4795 for more information. I don't see any other questions at this moment. So we will end it here, but just remember that this training along with the presentation will be up on our website at Housing Court Answers, and you can feel free to check out our older trainings, including this one which will be posted on our YouTube page. And I will post the number again, and thank you, Justin. This was super helpful.
I appreciate it. I love Housing Court Answers. And for people looking for help, Housing Court Answers are a great service. Their charity hotline is something I depend on, which I really appreciate the work they do on that. They've been around forever and they are a great part of the tenant community.
It's definitely thank you. All right, everyone, have a good evening. Stay cool. Bye.